In a formal communication to MPs on Wednesday, the Right Honourable Speaker disclosed that it has come to his attention that some MPs during recess, when they were not engaged in business of the House, evaded attempt by court officials to serve processes on them. He noted that it should not be the case and is calling for mutual respect between the legislature and the judiciary.
Attention has been drawn recently to the attempts by some members of Parliament to decline or evade service of court processes and documents while Parliament was on recess, and the honourable members were not on their way to attending at or returning from any proceedings of the Parliament. This situation has led to some confrontation with court process servers, while some justices have had to resort to the issuance of substituted service orders to ensure the smooth adjudication of cases before them. I also got to know that some members were arraigned before the court and charged with various offences without any notice to the Speaker of Parliament. This is an aberration and should not be repeated. Honourable members, we are all in agreement that the coordinate arms of government, while acting independently, must operate as an organic whole with due regard and respect to each other to ensure an equilibrium in the governance architecture and for the protection of the rule of law and the constitutional order.
He also expressed concerns about occasions where court processes have been served on some MPs when they were engaged in the business of Parliament without recourse to the Speaker, which should not be the case.
Article 1181 of the Constitution provides that, I quote, "Neither the Speaker nor a member of nor the clerk to Parliament shall be compelled while attending Parliament to appear as a witness in any court or place out of Parliament." Clause 2 of Article 118 provides, and I quote, "The certificate of the Speaker that a member or the clerk is attending the proceedings of Parliament is conclusive evidence of attendance at Parliament," unquote. These provisions have unfortunately in some instances been disregarded by some court officials. Indeed, speakers of previous parliaments have sought to provide guidance on the enforcement of these provisions and have ensured that service of processes from outside Parliament on honourable members have been effected with the permission of the Speaker. To ensure that this situation is contained, I had cause to formally write to draw the attention of His Lordship the Chief Justice to the non-compliance with these positions by officers of the Judicial Service.
He, however, went on to lay out the guideline which, according to him, was developed in collaboration with the judiciary to guide how parliamentarians can be brought before court.
Flowing from the above, and in reference to a circular of the Chief Justice, I provide the following guidance to the House, to members of Parliament, to the clerk to Parliament, and to the general public. 1. That when Parliament is in session, there is a presumption in the normal course of business that a Speaker, Member of Parliament, or Clerk to Parliament is on his way to attending at or returning from proceedings of Parliament and cannot be served a process from any court or place out of Parliament whilst the person is in motion. 2, that when a Speaker Member of Parliament or clerk to Parliament is in the presence of Parliament, there is a presumption that the Speaker, Member of Parliament or clerk to Parliament is attending to a proceeding of Parliament and cannot be served a process from any court or place out of Parliament.
Meanwhile, MPs are to direct service of court processes to the Speaker if they are to be served when the House is on recess. When a member accepts service of a processes and has entered appearance, the member is said to have become a party and will thus not be covered by immunities provided under the Constitution.